Afternoon, everyone. Welcome, as always, to Thursday afternoon. That means it's time for a Hines webinar. I am Chris Irons, Strata advisor with Hines Legal, former Commissioner for Body, Corporate and Community Management. With me today, and looking far better dressed than me, Frank Higginson, Senior Partner, Hines Legal. Frank.
Senior Partner, I've got a new title. Unreal. Yeah, I thought I'd wear a collar. Thought I'd dress up.
Yeah. All right. You've done better than me. Sorry, everyone. Today, unruly people in Strata. Now, originally when Frank and I were coming up with these ideas and setting the schedule for the webinars, we looked at the timing of this one and thought, hang on, Schoolies will be more or less on at about this point. So it was going to be a Schoolies related one. And then not only because we didn't want to tar all Schoolies with the same brush, but because it's a broader topic than just that, we expanded it to the idea of unruly. Before we get into the nuts and bolts of it, as always, don't forget to like and share, please. It's for everyone who does that already, thanks very much, much appreciated, but please keep doing so. All of these webinars are available on our Facebook page for your viewing pleasure at a later date, and I know people are watching them afterwards, so thank you for doing that too. You can ask us questions as we go along. Just drop your question on the Facebook page and Frank and I will get on to that. But yeah, unruly people, Frank. I guess this now becomes a bit more of a prominent issue, doesn't it? We are, gosh, how many days away?
Tuesday. Yeah. We allow Victorians back into Queensland.
Yeah, so we are 5 days away from Queensland being open for business. And I think what that means is that pretty much every holiday location in the state from this point on, it's going to be chockers, isn't it?
Yeah, absolutely. And I was talking to because for our practice is body, corporate and management rights. So I've got quite a few management rights clients in Noosa. And he was telling me the other day, one of them, that traditionally Australians are very late bookers of domestic holidays, whereas we're very forward-looking bookers for international holidays. But that has changed a lot. And I know even when we tried to book a holiday on short notice for the long weekend we had up here, which was going to be the Ekka show day, everything was gone. Yeah. So I think probably, and all the short stay clients we've got in management rights are absolutely saying that they are full.
And so the lesson here for everyone is that when you've got short-term accommodation in an apartment complex at capacity, and particularly when you've got a number of those buildings in a concentrated area in places like Gold Coast, Noosa, Port Douglas, Cairns, wherever, Airlie Beach, you can expect that any kind of noise, nuisance, unruly behaviour, the potential for that is magnified, isn't it, Frank, at that point?
It is. It's just more people, more potential problems, you know. Yeah. That's the reality of it. And I suppose today, I think at the end of this, we'll talk a little bit more about unruly people in a long stay context, because that applies equally. But the reality is that a lot of the questions that come across our respective desks relate to more immediate issues of people that aren't long-term tenants causing grief.
That's right. That's right. So look, I mean, Schoolies is kind of sort of happening at the moment. There was a fairly public Schoolies incident at Noosa just a couple of days ago, and it looks like it's not happening on the Gold Coast this year. It's gone elsewhere. But it's still happening in different points. But look, even though Schoolies isn't happening, it raises this issue of what happens when you've got somebody at your scheme and they're getting unruly or they're getting rowdy and they're causing a nuisance. And the obvious examples of that are people in the pool late at night making noise, maybe glass around the pool, people having a party on the balcony, and maybe not even a party, Frank, but just you're on the balcony, it's warm, you feel like a bit of fresh air, glass of wine, chatting with friends and family, and suddenly it's 12:30, 1 o'clock, the noise is travelling, isn't it?
It is. And I mean, for me, the prime example for me with that is playing 500. Suddenly you can play 500 and then suddenly it's 1 o'clock in the morning, you're a couple of bottles of red wine in and you're having the greatest fun known to man or woman, and you're calling.
You've just slammed down Misere
and noise, and away we go, and there's screams and laughter.
And then suddenly someone's banging at your door saying, can you shut the F up, please? Yeah. But that, nobody's trying to diminish that, are they? I mean, that is disruptive, particularly if you've had a long day, or you're struggling to sleep, or whatever the case may be. So, okay, there it is. That's the problem, I suppose, in a nutshell. There are some existing legislative tools, Frank, and it's fair to say, though, that these are more geared towards longer term
They
people,
are.
aren't they?
And the biggest issue we have with bylaw enforcement is the lack of the immediacy of the ability to do anything about it. That's the reality. So, and you come back to the legislative reform in relation to the amendments to the Act that were proposed. There were proposals in there, particularly around towing cars. So towing cars, I think, is becoming more of an issue in in tourism markets that used to be fly markets and now they're drive markets.
Yeah.
Airlie Beach is one, for example. I don't think it's had towing issues until the last couple of months as people drive in. But certainly in Brisbane, Gold Coast, Sunny Coast, there's always been those issues. So there was a proposal, in effect, to allow bodies corporates on relatively short notice compared to the 3 or 4 month process to get a commissioner's office order to tow a car, to remove cars. And now that's not there yet, and that's, I think, one of the really big things with bylaw enforcement. It's all well and good to have them, but there's no ability for a body corporate to exercise self-help remedy in terms of their own bylaw enforcement. They can't go and tow the car unless they've got an order from your former office.
Yeah, and that takes some time to put it mildly. So there is that, and then there's this mysterious thing called nuisance, Frank.
Yes. So I suppose 2 ways to deal with this. Section 167 of the Act refers to nuisance. There's also the ability to create a bylaw that gives you a little bit more strength. So you've got an alternative way to approach dealing with something that is causing a nuisance. And I think probably for me, mate, and I've said this before, so if you're a frequent watcher, you'll have heard this. If it's the first time, then great. Welcome to one of my favourite catchphrases, is that what the legislation prevents is conduct that interferes unreasonably with other people's use and enjoyment of their lots. What it doesn't prevent is conduct that interferes reasonably. So what that means, in community living, there are going to be instances where your amenity is interfered with.
Yep.
That's the reality of it. Doors will slam. There will be kids playing violins. There will be potential arguments with your neighbours. There will be music from time to time. There will be smells potentially wafting around the corridor. There will be kids playing on driveways.
There'll be people traipsing sand through the lobby.
Yep, it's part and parcel of community living, and that is the price you pay, in a sense, for living in a body corporate. So there's a degree of live and let live that needs to come with these things, and certainly we get hit up all the time in terms of bylaw enforcement with doesn't quite get across that threshold in terms of unreasonable interference. And I recognise that's grey, and that's not a black and white answer, but that is the unfortunate reality of the legal position.
Yeah.
And it's probably, to be honest, mate, where we make our money as lawyers, because there's always has to be an element of interpretation that can be a little bit subjective from time to time, and that certainly is going to be that, because what's unreasonable to me might not be unreasonable to Chris, but might be unreasonable to you. So there's that balance all the time.
Then that leads to the question of, are the bylaws fit for purpose in the first place? So if you've got, for example, an owner for whom there is a recurrent problem with them or their tenants or their occupiers, is there a bylaw that can be considered, and maybe not just for that owner, but just generally, which throws some onus of responsibility back onto the owner to, as I say, take some responsibility for what is going on in that lot. So sorry, go on.
So there was talk about, the legislative reform did raise the prospect of owners being accountable for the conduct of their tenants. Now that at the moment is not the case under the existing legislative regime. Again, subject to where we get to with amendments to the Act, with a new Attorney General, with a new Queensland State Government with a fixed 4-year term. That'll be a really interesting thing for those in the strata industry about whether owners can be held to a degree responsible and potentially financially responsible for the conduct of their tenants.
It's a fair point. Let's talk about the old thorny issue of Airbnb for a moment as well, because that is often associated with unruly behaviour. So Airbnb has made a lot of noise of late, irony alert, has made a lot of noise of late about what it is attempting to do in relation to parties. So my understanding, and I don't profess to be an expert about the internal workings of Airbnb, but my understanding is it's a twofold approach. On the one hand, they have said, I believe, that they are actively going through listings and looking for listings that are obviously designed to attract people for parties, and I have actually seen listings like that, so I know it happens. And then the second part of that is if something actually happens, the removal of that listing following, I guess, complaints from other people or notification about it. All well and good on the surface, isn't it, Frank? But I mean, that relies upon the provider taking those actions and taking them efficiently. Yeah.
Absolutely. And you know, Airbnb gets pilloried in a sense, and it's almost, I mean, it's the name of a company, but it's also sort of become a descriptor for people self-managing their own short stay properties. There are a bunch of other platforms and ways to do that as well. So for me, one part of it is Airbnb having their policies great, but if they execute an owner who then just moves straight to another platform and starts doing the same thing, it really doesn't help anyone get to where they need to get to. And I suppose that sort of leads to a degree, you know, back to that management rights piece. And I know management rights can get pilloried from time to time. You know, there's certain segments of the strata sector that are against it in relation to long-term contracts and all the rest of it. And usually those disputes or those issues relate to the caretaking side of things. From a management rights side of things, the other side of the coin is usually the letting. And a good on-site manager in a short stay building will have control over the tenants they put in their units. So you're not relying then on a third-party platform to later execute the owner and remove them from the platform when they move to somewhere else or whatever. A good on-site manager will straight away deal with the issue and potentially turf those people out of the property, because that should be in accordance with the terms of their license agreement that they've got to occupy that property. So, you know, this management rights piece that it does have some upside control of the tenants, the marketing of the property. I could go on for a while, but really that immediate ability to deal with a tenant or a short stay occupant from a management rights perspective is something that I think is significantly underrated by some who don't understand the value of the management rights model.
Yeah, look, I think that's a really good point, Frank. I mean, there are sometimes when something goes amiss, Unruly, there is no substitute for having somebody there who can potentially do something about the situation.
Yep, agree.
There it is. So, okay, we've talked about all of that. What practically can be done? Let's think about that for a moment, because I'm sure people watching this are who either are in that situation or who are anticipating that they might be in this kind of situation in the not too distant future. Well, we begin with the most obvious one, and that is to contact the police. And there are obvious situations where the police need to be called. So if there's violence or if there's threats, if there's underage liquor consumption, quite relevant for schoolies and probably at other times as well, drug use, disturbances of the peace.
COVID rules.
COVID rules.
Breach of COVID rules.
Yes, breach of COVID rules, absolutely. So that's not too much of an issue just now, but it may well be an issue in the not too distant future. Again, you can't discount that. Look, and I know that sometimes when we've had these kinds of discussions with clients and they've said back, oh, we called the police and they did nothing, or they can't do anything and they've been out here. It's very difficult to be able to offer many more options if police have already been involved and there's nothing else happening at that particular point in time. No, there's nobody else that's going to come in over the top of the police at that moment. Yeah.
No, and even then, mate, private security, you know, sort of sometimes when Schoolies was on, they might contribute to buildings who are open to them to contribute towards private security. You even go back to Indy and the Gold Coast 600 back in the day. Buildings would put security on knowing that there were going to be potential disturbances. So again, it's an expense to the building. I get that. Potentially that's for the benefit, you know, the income being earned relating to that expense is really to the people that are renting units probably in that premium period for it. But security comes at a cost, but they'll also then be licensed and trained potentially to deal with those disturbances if the police aren't, not necessarily police threshold, police are too busy, and even the appearance of security in itself is a disincentive to bad behaviour. So maybe that's a price that a body corporate might be willing to pay for some security around, I suppose, pardon the pun, for ensuring that people know there might be consequences for bad behaviour. So
let's tease that out just a little bit. So we're almost at the start of December, and you know, for example, that your building is likely to be chock-a-block in 4 weeks' time, Christmas, New Year, and probably well beyond that point as well. And you know that based upon history, there might be some disturbances, and that might be because there's a couple of pubs very close by, or that for whatever reason your building is very attractive to young people or younger people or a particular kind of traveller. So, okay, you know that from experience, this might happen. So, okay, let's talk about security as an option. So, first of all, it's a cost-benefit analysis. Is it worth whatever money is spent by the body corporate to engage security? And I guess you have to weigh up all of the potential costs that are incurred. But it's, as you said, Frank, it's the peace of mind and the deterrent factor as well.
And mate, we just helped the body corporate put in place effectively a sort of security style concierge agreement for a 12-month period as a trial, where the existing resident manager is going to be given some additional money to manage some additional resources. And so that security person is not sitting there with a big stick to belt people that play up at midnight, but also to welcome people to the building, to give them some directions, to potentially help them with their luggage. So it's sort of a combination style thing. So part of it then comes back to the quality of the person employed, which the body corporate's going to have a say over. So that body corporate's recognised that there's some issues that happen in a building of this size and this style of occupancy, but there's also some other things that that person can do to sort of bring amenity to everyone. So that'll be really interesting to see how that goes over the next 12 months, you know, and not hideously expensive on a full-time basis, but yeah, it's sort of recognising that, you know, it'll be great to sit here and say, oh, there's perfect section of the Act that says if someone's playing up, you can go and lock them out and get them turfed out and all that sort of stuff, and that's not there. So no. It is a matter of looking at what are the other ways to approach these issues, and that's absolutely one of them. Right.
Depending on cost, that can be potentially agreed to at committee level, potentially, and could be relatively quickly done as a potentially even a vote outside committee, I would suggest. So I would think you got no substitute for getting it done now. You really do need to get onto it, but that's something to think about. Similarly, I go back to my point just a few seconds ago. If you know that your building is in close proximity to the pubs or bars, nightclubs, or it's in a particular location that's attractive for that, there is absolutely nothing wrong with going and talking to the publicans, the licensees of those establishments, and saying, guys, look, we're having this recurrent problem, or we know that we've had these problems in the past. What can we do? What kind of collaboration or what kind of things could we jointly do to get an improvement? Because don't forget, if you are the licensee, if you are in control of a licensed premises and something happens either on or nearby your licensed premises, your license is in jeopardy at that point, potentially. So you would be surprised at how motivated a licensee could be to have that discussion with you as a body corporate.
And it might, the least of which of those signs when you're leaving, you know, be aware we're in a residential area, so be respectful of the other people that are living here and sleeping when you leave. You know, you see those on the way out. Not that I party too much to midnight these days, but yeah, I have seen those signs before. You know, just one helpful little, again, trigger from the publican to actually sort of remind people what's going on.
Yeah, but as a minimum, you're getting it on the table and you're letting them know there is a problem going on here. They do need to know about that because, as I say, it is absolutely licensees are held responsible for things that go on or near their premises. While we're on this topic, a body corporate can't evict and can't fine anyone, can they, Frank?
Nope.
So that's off the table. As much as people would like to do that, they can't do that. That's not the body corporate's role or responsibility. Similarly, a body corporate can't discriminate between different types of occupiers. So you can't, for example, have one set of bylaws for owners and one set of bylaws for tenants. That's not how it works. It has to be the same for everyone. And there's not really any leg room about that or wiggle room on that, is there, Frank?
No, straight to Section 180. You know, it's been, I suppose, our legislature in 1997 knew that there was the potential for those sort of issues, so they've absolutely carved it out. So it's not, I suppose, what is it, 4 legs good, 2 legs better type stuff. No, there are one set of rules and they are applied equally to everyone who's an occupier. And so the Act actually creates a definition of occupier, and that occupier includes owners, but also includes people that are staying there on a short and long-term basis.
Yep.
So everyone's subject to those bylaws.
We've talked a bit about rules, but one thing we haven't talked about is making sure people know about the rules, communication of the rules.
Absolutely.
So it's all well and good to bang on about rules. You've got to make sure people are aware of the rules. That's number one, but probably for me, the bigger issue is how you make people aware of the rules. So there is a big difference in how you do that. Human nature, I think, please tell me if you think I'm wrong, Frank, but human nature tells me that if you put up signs everywhere and all of those signs say no, 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 don't do this, don't do that, big crosses on everything. So you've arrived at an apartment complex and the first thing you do, I want to go and have a swim. Great. So you get ready, you go down, get in the elevator, go out for a swim. Signs everywhere. Don't do this at the pool. Don't do that at the pool. Don't bring this to the pool. Pool hours are this. You will face these consequences if this happens or this happens or this happens. The more times you tell somebody no and don't do it, I think the more likely it is that they're probably going to do it.
Absolutely. I think probably for me, fundamentally, there's two things. I think Australians, we are all Australians, don't like having that thrust down our throats. And the second thing, and I've said this to clients 1,000 times over the years, don't threaten something you're not willing to do.
Yep.
You're not willing to follow through on. So if there's something there saying, if you do this, this will happen, and there is misbehaviour and nothing happens, then everything else is academic. Doesn't matter. And even, we stayed Chris and I went on a tour at North Queensland, a couple of weeks ago, stayed in a property in Cairns. Inside the door, big no party policy. And I think even when we checked in, we were told about that too, weren't we?
We had to sign something, I think.
Yeah. So very clear they made it very clear to us what the deal was. And the other thing, I come back to.
But let's talk about that for a minute. I felt personally insulted by the whole thing. I'm rocking up there, and look, they were lovely. The people were lovely when talking about it, but I felt insulted. It's like, well, yeah, I can see that there. I know what's expected of me when I am going. If we were if we were a bunch of 18-year-olds with a couple of slabs on our shoulders as we checked in, sure. Tell us by all means, no parties. But couple of middle-aged, let's say that, blokes showing up in business attire, I don't think that's the way to go about it. So you've got to pick the right methods, don't you, Frank?
You do, and it is managing expectations. I mean, when I was first starting out, I suppose, so 20 odd years ago, Schoolies arrived. Lots of on the Gold Coast at that stage, lots of clients in short stay buildings. And I was talking to one of them about, so how do you deal with this? How do you manage this? And he said, Frank, it's very simple. They just need to know the rules and they need to know there are consequences if they don't follow the rules. So everyone who came into his building, and this is well before, I suppose we had the interweb the way we do now and all that sort of stuff, had a very clear one-pager, which, not in tiny little fine print. These are the most important things when you're staying with us. And if you breach those, this is what's going to happen. And he said to me, all you need to do, Frank, is make an example of someone on the first night and make sure everyone else knows that there's an example being made of someone on the first night. And that's the last of the bad behaviour. So the first night, the Friday night, is the one where you need to be on your guard. And after that, you're fine. And then when New South Wales people roll in, you do the same thing. So it's 2 bad nights and 14 days otherwise of great income.
But look, again, coming back to my communication issue, there is a different way. So instead of saying no, don't, present it differently to people. Assume people are adults or assume they have an ability to act like an adult and present it to them in terms of, here's a great facility or here are great facilities. We've got this great building. We simply ask for your cooperation on these things. If it's the pool, for example, and you don't want glass in the pool, everyone understands why you don't want glass in the pool. Fair enough. But instead of putting a sign every 2 meters saying no glass, no glass, no glass, you have a different way to present it. It's like, look, we love this pool. It looks fantastic. To help maintain this great pool for you and everybody else, please request only use plastic in the pool. That's a better way of putting it. It might sound touchy-feely to everybody listening. I get it. I firmly believe you get more flies with honey, always.
Yep.
Couple of questions have come in before we do a bit of summing up. Julianne, Hello again. Thanks for continuing to tune in. Julianne, you've listed a lengthy list of issues there. Caretakers and committee are ignoring complaints. What can owners do? And I think this is also a question that comes later on from Rian. And again, Rian, thanks for tuning in again. This is a situation where you've got bylaws that are being breached, seemingly, and the committee is not following through on the enforcement of that. So this is the subject.
You've also got some criminal behaviour.
Yep. Yeah, you do.
Nudity, slingshots, property damage.
Yeah. So in the first instance, separate out body corporate responsibility from criminal, I think is the first thing that you do. Body corporate has to exercise its responsibilities to enforce bylaws. That's its job. If it's not being done, then the individual can follow through on that process, and there is a prescribed process for the individual as opposed to the committee to do that process. Chris, what about committee members allow kids to ride skateboards and bikes without helmets? Is that a criminal offence, Frank?
I suppose we're going to get into the distinction of what's common property and what's not common property. Sorry, what's common property and what's a public roadway. I'd suspect there's something there. But the other thing for me is it's not a body corporate's responsibility in relation to kids wearing helmets.
No.
You know what I mean? A body corporate's responsibility is to administer and regulate the common property. To me, I don't think it's reasonable. I don't think a reasonable bylaw would be to say kids can't ride bikes on common property. And it also, you know, to me, a better analogy in a sense is the pool. There's no, you know, body corporates must have pool safety certificates and the right equipment and warning signs and resuscitation charts and all that sort of thing, but they don't have to have lifeguards because there is a degree of personal responsibility that people assume when they're using a pool. So if someone drowns, provided a body corporate has done all the things that it's required to do at law, as tragic as that might be, that's not going to lead to potential liability to the body corporate. And it's the same with there. If people allow their children to play on the road, in a sense, it's no different to, I live in a house, if my neighbour's allowing their kids to play on the road without helmets, making noise, uncontrolled, it's not my problem. It might lead to bad consequences for that family, but that is not my problem as an adjoining lot owner. In the body corporate, that's the same sort of thing. It's just, if that's the way they want to do it, that's what they do.
And Chris, further to your comment, you've talked there about committee members that allow that. No different if you're a committee member or not a committee member. It doesn't make any difference. There's no exceptions for committee members for enforcement, but everything Frank said equally applies, whether you're a committee member or not a committee member. Looking ahead then, I think what this conversation, we've had a few similar discussions like this in other webinars, haven't we? I think what really becomes obvious is that there is absolutely now time for government to look at some suitable reforms here, appropriate reforms to give bodies corporate a few more tools to deal with this kind of situation. Because if bodies corporate are expected to manage the property themselves via a committee and owners taking responsibility and all the rest of it, they need to be given the power to do so, don't they, Frank? They need to be given some immediacy.
They do. And I suppose it's sort of interesting. One of the things, or one of the many things I've learned from Chris in his almost 12 months with us is the machinery of government is enormous. And probably, mate, if I was going to put words in your mouth, I'll say this, and you can tell me whether I'm wrong, is now would be the time to actually go and have a conversation with your local member, be that Labor or LNP, because we have a new government, or other, there's a few others, absolutely. We have a new government that is going to be elected for a fixed 4-year term. We have a new Attorney General whose slate, to a degree, might be relatively clean in terms of previous experience with these things. So if you wanted to advocate in relation to any of these issues, now would be the time, because there's certainly on the agenda is reform. We've had discussion papers about reforms of the Act and bylaws and Section 180 and all those sort of things. We've still seen nothing in detail yet. So now would be the time to go and have those conversations, because that's ultimately where it gets to. We're sitting here, and if there was a magic wand I could wave to make all this stuff go away, it'd be great, but it's not. So part of what we're trying to do here, in a sense, is help people understand the reality of the situation so they become a little bit less frustrated with it. But there is realistic possibility of change coming. So now would be the time to strike.
As Frank said, your local MP, or if you want to advocate through a group, that's fine too. But you just need to be clear about what it is that you want. So, and Bob, you've thank you for your comment. You've hit the nail on the head. Reforms must be practical. Of course, they must be. And there needs to be an emphasis on immediacy. So we've talked about the tools that are already there, but as we've said, they're long-term options. You're not going to get a bylaw enforcement in 24 hours. It's more like 24 weeks. So there needs to be a tool available to a body corporate to exercise control and manage things appropriately. What that looks like, what form that takes, let's have a discussion about that. Open up the discussion, but as Frank said, and I absolutely agree, now's the time to be doing all of that. And look, just finally, we started out with Schoolies, and we'll finish up with that topic. So didn't really happen much this year, but it might be back next year, or it might be back in a different form, or it actually might be back even bigger next year because it didn't happen much this year. So what does that mean? It means now, not 12 months time, but now is the time to start preparing and doing something about it.
And actually, one observation with Schoolies, I think the difference that was going to be this year is this would have been the first year of Schoolies through grade 12 who'd started at pre-prep. So effectively, they're all 18, or most of them are 18, because I think the issue used to be Queensland Schoolies were all 17, therefore couldn't go out. New South Wales New South Wales were, and therefore could. So there was more nightclub action there and not as much unit action. So quite possibly there may be less sort of in-house Schoolies issues next year because all of the school leavers are usually going to be 18.
But now's the time to start. You don't start in 12 months' time and do it in the great tearing rush. Start planning now. Start advocating now if you need to. That's that same process we just talked about, going through your local member. And I just want to highlight one quick question there at the end from Daniel, who has asked, does that mean the new AG might be looking at bringing BUGTA into BCCM? Daniel, your guess is as good as ours.
But we're doing a BUGTA seminar. We're doing one of these BUGTA in a couple of weeks, aren't we?
Thank you, Frank, for remembering that, because I had forgotten. We are indeed doing a BUGTA seminar in the very, very near future. But Daniel, in answer to your question, we don't know any details, but it's possible. It's possible. But if you want that to happen, I suppose the point is now is the time to be asking for it and to be advocating for it while there is a new attorney, fresh, with a fresh agenda. Get into it. And look, a woohoo on a BUGTA seminar. What a way.
Add another George Orwell quote, like we're flying today, 1984, here we are. It's an Animal Farm, really, wasn't
it? Yeah, I think so. Look, we've come to the end, and as always, time has flown. So, look, I just want to say thank you to everybody for offering comments, and particularly for people who keep tuning in each week to watch and engaging. Thank you. We really do appreciate it. I know everyone's got stuff on and is busy, so thank you for taking the time. And hopefully we've gotten somewhere on a tricky one this week.
Yeah,
tricky
black and white one.
Yeah, absolutely. Frank, as always, it's been a pleasure.
Absolutely, mate. Likewise. Thank you, everyone.
We will see you all next week.
Done. Bye.
Bye-bye.